Greg, would you please rise and raise your right hand? The court reporter will swear you in, sir.
Do you solemnly swear the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Gregor, are you under the influence of any alcohol, drugs, or medication?
No, Your Honor.
You understand you have a right to testify in this case in your own defense. Conversely, you also have a corresponding right to remain silent and not testify in this case. Do you understand both of those rights?
I understand.
Have you had a full and fair opportunity to meet with your attorney to go over that decision?
Yes.
If you elect not to testify and thereby exercise your constitutional right to remain silent, no one may comment to the jury on your decision not to testify. Not me, and especially not the prosecutor. Do you understand that?
I do, Your Honor.
If you decide not to testify, there is a charge I would give to the jury with your consent. That charge would be, quote, as you know, Christopher Gregor elected not to testify at trial. It is his constitutional right to remain silent. You must not consider for any purpose or in any manner in arriving at your verdict the fact that Christopher Gregor did not testify. That fact should not enter into your deliberations or your discussions in any manner at any time. Christopher Gregor is entitled to have the jury consider all evidence presented at trial. He is presumed innocent whether or not he chooses to testify. Do you understand that charge?
I do.
If you choose to testify, the state would be permitted to cross-examine you. In other words, you wouldn't be able to revoke your decision after you testified on direct and not be subject to cross-examination. Do you understand that?
Yes, Your Honor.
After having met with your attorney and discussed the matter, let me back up. I also previewed this with you last week as well to give you notice I was going to have this hearing with you. Is that right?
Yes.
And between then and today, have you had time to consider what decision you want to make?
I have.
And you understand this is a decision that's personal to you. You're certainly expected to consult with your attorneys, but ultimately the decision whether you elect your right to remain silent or elect your right to testify is your decision. Do you understand that?
Yes, Your Honor.
And have you reached a decision, Mr. Gregor?
I have.
And at this time, can you tell me what that is?
I will not testify, Your Honor.
Mr. Gallucci, are you satisfied that your client is making that decision knowingly and voluntarily?
Yes, Your Honor.
Mr. Gregor, do you feel forced or pressured by anyone to elect not to testify and to remain silent?
No.
You're making that decision of your own free will after you've had sufficient time to consult with your attorneys?
Yes.
Thank you. Anything you'd like to add, counsel?
Your Honor, I have, as is known, spent many days down here in Ocean County meeting with my client and prepping him to testify. He has been very truthful with me all along about his desire to or not to testify. We've gone through it at length. I prepared him last week, and then, as you know, I became ill. I was still in communication with his family, and his family was in communication with him during that time. So I believe that I've spent a significant amount of time with him, that he has considered all of the ramifications, the pluses, the minuses, whether to testify or not to testify, and I'm satisfied that he understands the ramifications or non-ramifications of the decision not to testify.
Thank you. And you're also satisfied that if he elected to testify, you had prepared him for the testimony and the cross-examination?
Not only was he prepared, but I was prepared to do direct examination, and I was also prepared to encounter a cross. Hold on, my co-counsels. Yes, Judge.
Thank you. Anything from the state on that issue?
No, Judge, thank you.
All right, so do you want me to bring the jury back? Well, like this, let me back up. Is there already any other defense witnesses?
There are no other defense witnesses. There were 3 exhibits I wanted to enter evidence before I rest, but...
All right.
Yeah.
Well, why don't we do that now, then?
All right. I believe they are...
Can we go over all of them that we put in?
Judge, can we see and compare like we did with ours, what's already in, so I have it for my notes, please?
Yes, so the only defense exhibit I have in now is D10. That's a letter from Kim Peace to Mr. Gregor, which went into evidence on May 1, 2024 at 11:38 a.m. I have no other
Judge, I have D16 going in.
Oh, I'm sorry, that's on another page, you're right. Problem is I don't really have a defense exhibit list, so. What's D16, Madam Clerk?
D16 was the Arkansas map.
Oh, I'm glad you're with me, Michael Jaffer, because yes, we got to hear from the defendant in his own words. However, he is not going to testify. Are you surprised or not?
I'm very surprised. Anytime that your child dies at your hands and it's on videotape, I don't see the logic behind not testifying. But also what I'm noticing, Judge Ashley, is this case screams lesser included charges. In New Jersey, near the end of a trial, the judge can allow the prosecutors and the defendants to do something called a charging conference where they would agree on lesser included charges, right? Maybe that's why the attorney told them not to testify. I don't know. But this case screams lesser included charges. This man deserves to go to jail. Look at what he did to his kid. I mean, it's clearly this man deserves to be in prison, right? And he's going to be in prison in his mind for the rest of his life anyway. But is this, murder one? I don't see it's murder one. It's murder, but I don't know about murder one. This case screams lesser included charges. I don't know if that has happened yet, and if not, I would be puzzled as to why.
Well, let me push back on that, because the last witness we heard from was Dr. Bodden, and he testified that the cause of death was natural causes from the CPR, and then he specifically said that the bruises on the child were not related to the death. Is that enough for reasonable doubt for this jury to say he didn't kill his son?
I don't think this is murder one. I don't think this is murder one. I don't believe that this is murder one. I believe that there's some form of negligence, some manslaughter here that happened, in my opinion, based on the fact that he put a kid. I mean, even the treadmill tells you a blatant sign, this is not for minors, right? And so I definitely do not believe that this is murder one. I believe there's ample reasonable doubt that this is murder one. That's why I think lesser included charges, might be justified here, but yeah, definitely not murder one.
And I think they might be justified, but I don't know. I think the right juror could hang on to Dr. Bodden and say, no matter what he did to the child that was abusive, he did not kill his child. We'll have to wait and see.